Good afternoon, everyone. We are pleased to have you on this webinar. FCMB Trustee is a major player in both corporate and private trusts. And Islamic wills and trusts is one of the tools that we have developed for estate planning under our private trust products. I can assure you that we are going to have a wonderful session today, and it's going to be as interactive as much as possible. The guest speaker is well versed in the topic under discussion. So I welcome you, and I hope you enjoyed the session. Thank you very much.
Thank you so much, Mr. Adesomi. For those of you just joining us, we say welcome to you. This session is put together by FCMB trustees, and the topic is Islamic law of inheritance and wills, Wasiyyat. We have with us our guest speaker for today. However, before I introduce the guest speaker, please note that the question and answer session will be after the presentation by our guest speaker. If you have any question while the presentation is ongoing, kindly drop them in the question box if you're joining us via Zoom. And if you have joined us on Facebook, kindly type your questions in the comment box. Thank you. Our guest speaker for today is Umahani Ahmad Amin. Umahani Ahmad Amin is a legal practitioner with over 15 years multifaceted experience of law, particularly in finance and capital markets. She is the managing partner of the Metropolitan Law Firm, a full-service law firm headquartered in Abuja and specialized in broad Islamic banking and finance practice, which she founded in 2008. Her immense contribution to the advancement of the niche area in Nigeria and the recognition as a subject matter expert in the Islamic industry. She is a member of reputable professional institutes, such as the Institute of Directors, Society for Corporate Governance, Non-Interest Finance Association of Nigeria, and Association of Investment Advisor and Portfolio Managers. She also sits on the board of various organizations, including the Nigerian Exchange Limited, 117 Capital Limited, and Salam Thankful Insurance Limited. Umahani, we are pleased to have you. Over to you. Thank you.
Thank you very much, and good afternoon, everybody. Thank you for joining us today. So our topic today is Islamic estate planning, specifically on Wasiyyat. I will be sharing my screen right away so we can start. I'd like to start by saying that it is very, very important for every Muslim, for everyone as it is, to set up a system and a structure to ensure that upon death, all assets are distributed in accordance with one's wishes. So, and this is what we call estate planning generally. The estate planning process will ensure and take into account that the financial affairs for all legal heirs and beneficiaries are adequately addressed. And this takes us to the Islamic perspective. So one of the rules of planning and managing wealth distribution is to avoid your assets being frozen, usually once a person passes away. Therefore, managing and planning an Islamic wealth distribution is very, very important in the life of every Muslim and the community at large. There are various types of instruments that can be applied in managing and planning an Islamic estate. And this could be, as per the Quran had said, via Wasiyyat, Waqf, Hibba, etc. However, today we are going to be specifically talking about Wasiyyat. So generally in Wasiyyat, Wasiyyat is will. writing a will under Islam. So generally, about 90% of Muslims do not make a wasiya. And this is because they are unaware of the importance of wasiya and would hold off from dealing with the matter of inheritance. Usually everyone is scared of thinking about dying sometimes and all that. And a lot of people do not want to discuss that or even try to put it in writing. At times, some even give the reasons of not having enough assets for them to draw up a wasiya. But it is very important that wasiya should be done for every Muslim, as it's not usually because of whether you want to distribute assets or not. It goes beyond that. It delivers like paying off your debt and delivering your last wishes to the family members, with usually messages of spiritual thoughts. There's a hadith of the Prophet sallallahu alaihi wasallam that talked about wasiya. It was narrated by Umar ibn al-Khattab, and he said that it is the duty of a Muslim who has something to which is to be given as a bequest, not to have it for more than 2 nights without having his will written down regarding it. This is by Bukhari and Muslim. Although having wasiya in place is a favorable thing, that is sunnah for you, is not compulsory, it's sunnah for you to have it. But then it becomes mandatory in a few ways, which I will highlight now. So it becomes mandatory when a person has a responsibility that must be fulfilled, especially in the form of zakah and pilgrimage, which we will also discuss in the next slides. And then that becomes compulsory. If you have to give zakah, you have not given, and if you have to go for pilgrimage, for example, and you had already made plans, then those will be fulfilled even after you're deceased, because someone might, for example, go for Hajj on your behalf to fulfill your wishes. So it becomes favorable, that is sunnah, when bequests are given to relatives, that is the non-faraid beneficiaries in need of assistance, while they're not even entitled to inheritance. The same becomes favorable if assets are bequeathed to the poor with the intention of doing good for the purpose of, or for the virtues of Allah. So we have Quranic verses that have also talked about how these shares can be distributed and how it can be done through the Quran and the Hadith. Of course, the Quran is the main source, and in Surah An-Nisa, it has been specified how the shares will be distributed and how we have the Quranic shares. From these verses, you can also deduce that faraid is applicable upon the demise of a Muslim, and that the entitlements will be distributed after honoring his legacies and the settlement of his debts, such as burial expenses, loans and debts to be owned by the deceased, and then of course bequests, that is the wasiya we are talking about. And then I had said it can be compulsory, it can be favorable, that is, it can be sunnah, and it can be neutral when you're giving it to a rich relative. When you're giving it to a rich relative, and it becomes disapproved if you are giving it for the purpose that is not Sharia compliant, or you're giving it for the person who will use that money to commit sins and all of that. And it becomes haram, that is forbidden completely under the law of bequest, when something, when you're giving it with the intention of harming the heirs to the deceased. So under these laws, you cannot be able to give anyone the inheritance. Islamic law, as it is, sets out strict and rigid inheritance rules that will determine how a Muslim's estate is to be distributed between the deceased heirs and after his demise. The law further limits testamentary freedom to 1/3 of the deceased estate after the deduction of funeral expenses. And this is to say that you are entitled to give out 1/3 according to the hadith of the Prophet ﷺ, when his companion asked if he can give out all of his wealth in the favor of Islam. And the Prophet ﷺ said he cannot. He said, okay, how about half? He said, no, you can't. And he asked if he can give 1/3. And the Prophet said, yes, 1/3 and only 1/3, not more than 1/3. So if you have the testamentary capacity and the freedom to give out 1/3 of your property or assets, the rest will be shared. You have no say over that, which is the remaining 2/3, and will be shared according to the Quran. These heirs can be divided into 3 categories. That's, we have the Quranic heirs or sharers, we have the agnetic or residuaries, and we have the uterine or the distant kindred. The Quranic heirs or the sharers are those relations of the deceased whose shares have been determined by the Quran. Their shares and the order of preference in succession is fixed under the Quran. So you have 12 Quranic shares: the husband, the wife, father, mother, grandfather, grandmother, daughter, son's daughter, Jermaine, sister. That's one from the same parents. You share both the same mom and dad together. Then you have the consanguine sister, which comes after the one whom you share the same parents with, and then who is the same dad with you, and then the uterine sister from the same mother, and then uterine brother from the same mother. Now, these Quranic sharers also exclude others in the presence of a deceased having both his children, male and female, and his parents living. Then the consanguine and the germane brothers and uterine brothers will not inherit in the presence. In the absence of a deceased having in the absence of a deceased having children, then of course the germane sister from the same parents will come first. Then if in her absence, then the consanguine sister, and in their absence, then the uterine sister from the same mother but different fathers, and then the uterine brother will follow suit. Primary heirs among the Quranic heirs include the father, the mother, husband, wife, and daughter, and are never excluded from inheritance, though their share may be reduced in certain circumstances. However, their entitlement to inheritance is subject to rules of the application of the fara'id. The agnetic heirs commonly consist of male and sometimes female relatives that inherit as residuaries after the shares of the Quranic heirs is distributed. It is noteworthy that the Quran does not explicitly mention the shares of male relatives, such as the deceased son, but provides the rule that the son's share must be twice that of the daughter's. Uterine heirs, distant kindreds include any blood relative who is not a Quranic or agnetic heir. So I have a table here. According to the fara'id, each is entitled as follows. So if the husband is alive, is the heir, the wife leaves children, he's entitled to 1/4. And if the wife does not have children, he's entitled to half of what she leaves. For the wife, if the husband leaves children, she's entitled to 1/8. And if the husband does not have children, she's entitled to a quota, 1/4 of the deceased estate. And for the father, if the deceased leaves children, then he's entitled to 1/6. And if the deceased does not have children, he's entitled to 1/6 plus the residue. For the mother, if the deceased leaves children or the deceased have no children and more than one germane sister, the mother is entitled to 1/6. The deceased, if he leaves no children and one germane sister, then the mother is entitled to 1/3 of the deceased estate. For the son only, if he is the only one, then he's entitled to the residue. That is after every obligation has been fulfilled, then the son takes everything. And if he is inheriting with a daughter, then the son takes, they share in the residue in the ratio of 2:1. And if he's inheriting with another son, then it's 1:2. For the daughter, if she's the only child, then she's entitled to half. And if there are more than one daughters, then they are entitled to 2/3. So after that, then the residue will be, of course, shared amongst the residual heirs. And for the uterine brother and sister, in the absence of a father, brother, sister, and child of the deceased, and are the only Quranic heirs, then they will have 1/6. And in the absence of father, brother, sister, and child of the deceased, they are more than one, they are entitled to 1/3. So we have these rules, and this can be broken into 3 categories. We have the conditions of succession, and of course, the cause of inheritance and impediment to inheritance. So for the condition of succession, the fara'id can only apply after the demise of a person. So you cannot apply inheritance, of course, is after the demise of the deceased. And then, of course, there are heirs that have survived him. This is only applicable to the Quranic heirs who survived the deceased at the point of death, and this includes the fetus. Now, there are different opinions about how the fetus should be treated. For some school of thought, it was said that the fetus should be treated as a male child because no one knows what it will come out to be. So the shares of a fetus, perhaps the other inheritors would not allow for the fetus to be born first. Then the shares of a male child will be kept. And if it happens to be a female, then the share of a female, of course, will be given to the born fetus, to the born child, and then the rest of the half will be redistributed to the other heirs. The next one is a person can only inherit in cases where they're not excluded from inheritance, either through the exclusion by the Quranic heirs or by impediment of inheritance. An example of the exclusion by the Quran is where the existence of a son would exclude the consanguine brother of the deceased from inheritance. Exclusion by impediment refers to circumstances such as a difference in religion or the killing of the deceased. So if for the killing of the deceased, if it has been certified by a competent court of law that the heir is the person that had killed the deceased, then he will not be allowed to inherit. And of course, there are other impediments, like you cannot be able to give out in inheritance to your adopted child or to a non-Muslim. A non-Muslim could be your parent or any other person. So Islamic estate planning had provided for the tools where you can be able to give out under the 1/3, which you have a testamentary freedom to be able to give out to all of these other people, except of course the person that is accused of killing the deceased will not be able to inherit. So the second one will be the cause of succession. This cause of succession could be through marriage or kinship or blood relationship. So by way of marriage, of course, the woman or the man are also Quranic heirs, and they can be able to inherit through that. So this is a way a person can inherit under the Faraid. It is reserved for both husbands and wives. And for kinship and blood relationship, this is another way of inheriting that applies to the father, the mother, son, daughter, brother, and sister of the deceased. So they will inherit again after it has been established that the Quranic heirs have been taken care of or are not available. The third is impediment to inheritance. I had already said that earlier. One of the impediments to inheritance is homicide. That is the killing of a person with the intention of inheriting their estate. If the Quranic heir is convicted in a competent court of competent jurisdiction for killing the deceased of which he stands to inherit, then his right to entitlements will be denied. The other one I had earlier spoken about, of course, is the difference in religion. A Christian cannot inherit a Muslim, for example. So if a woman whose son is a Muslim is allowed to inherit, she can only be able to get anything, benefits from the 1/3 which the deceased has testamentary freedom of, on, and that also applies to adopted children. They are not entitled to inherit, but of course 1/3 has been provided for them to inherit. So prior to the distribution of the estate, that is the Faraid distribution, the execution of the following is extremely important. So the settlement of the deceased burial expenses, usually immediately after the deceased, the family and everyone else will not touch anything that belongs to the deceased, except of course his funeral expenses. Even food, you find out around us in Nigeria, people bringing in food as sadaqah because it is believed that whatever the deceased has left for his heirs. And the Quran is very strict about taking that which belongs to the orphans, for example. The second one will be the payment of debts. So if the deceased has debts, then it has to be settled first before anything is touched in his estate. So the payment of debt is usually when a person comes forward to say, oh, he owes such and such to, and these are his witnesses. Perhaps the deceased did not say anything about it in his will. That is why, or he does not have a will. So these things are very important, especially if the deceased owes or his estate has been under some form of instrument that requires for payment, then it will have to be settled first before anything is being touched from his from the estate. So now the next one will be the payment of zakah. So payment of debt under number 2 I had mentioned is correlates with number 3. So payment of debts is also the payment of zakah and nadar, which are vows, and of course kafara. So nadar and kafara. Nadar, for example, is when you vow that if, for example, if a person is childless and he prays to Allah that whenever you give me a child, I will be able to, say, pay charity every year, probably to maybe some institution, some charitable institution also. So this is a vow you have taken between you and Allah, and then it has to be sustained even after you're not there. And then the other one will be kafara. So you have this death of humans and deaths of Allah. So for kafara is atonement. So when you have, of course, done something again and you need to do a kafara, something against the religion, and you are meant to do a kafara, like you had an accident and killed a person, for example, and accidentally. In Islam, you are meant to fast for 60 days or feed for 60 days. So if perhaps you die within that time, of course, if you cannot fast when you're gone. So for the kafara, it will be given out on your behalf. The sadaqah will be given out on your behalf. And then number 4, of course, if you have claims against the estate, that will have to be settled again before you even go on to the Wasiyyat. The Wasiyyat, of course, will have to be followed after the death of the deceased. So for the next section will be on the Islamic perspective on wills. So a will is a testament, or a testament is the declaration or intention of what this deceased wills to be performed after his death. It is a formal expression of the testator, that's the owner of the estate, that is existing at the time of the death. According to the Sharia, a will or wasiyyah is defined as a testament which is to be acted upon after the death of the person who constructed it. It is very, very important for every Muslim who has something that can be distributed to show how it should be distributed. And succession planning is important for everyone. First of all, I say to give peace of mind in one's final days. A person that makes a clear wasiyyah and carefully considers what will happen to their wealth after their death can spend their remaining days with the knowledge that everything they've done in everything their power to ensure a smooth distribution of their wealth afterwards, and can leave the rest to Allah. The second reason will be to ensure security and well-being of the surviving members of the family. Without a wasiyyah, the security and well-being of remaining family members may suffer. People may believe that their possessions will automatically be passed on to their immediate spouse, children, family members, or even relatives from other places. So while this is the thought of the majority of people, this is unfortunately not true, as there is a legal procedure that can and needs to be adhered to in order to unfreeze usually the deceased assets. If a deceased person does not have a wasiyyah, this could mean that their wealth and assets may remain frozen until matters such as court orders and administrators and procedural matters are finalized. Therefore, the household members who may be immediately dependent upon the wealth of the deceased will not be able to withdraw any of the deceased money from the bank, for example, or even take care of their financial securities and possessions of, particular sentimental value. In addition to this, the deceased may want to leave some of their estate to members of their extended family who do not automatically inherit them from the 2/3. Unless they have made a wasiyyat, there is no guarantee that this will happen. It is narrated by Salman ibn Amir that the Prophet ﷺ said, giving charity to the poor is charity, and giving to a relative is two things, charity and upholding the ties of kinship. So usually you have relatives that are not well-to-do, or you have been the one taking care of them, and then after your demise, of course, nothing is going to happen to them. So you would like to have those in thinking about your planning in respect of your estate. So it also enables missed obligations to be fulfilled. So it can ensure that any missed obligation by the deceased can be entrusted to the family members in fulfilling this obligation. The missed obligation here can be religious in nature. That is, it can be Hajj, like I mentioned earlier, or non-religious in nature. That can be like unpaid loans. It is a belief that among Muslims that should the remaining religious obligations of the deceased remain unfulfilled, this will cause him distress in the hereafter. So the next slide, I'm talking about matters that will be addressed in a will, and this will include the appointment of an executor. So you list the heirs, and then distribution of the estate, and then you list the liabilities of the deceased, and then specific instructions to the executor. Specific instructions will be the manner in which this will be distributed, and how and when, what time, and all of that are specific. And these specific instructions also in the will also contain sometimes how a person wishes to be. So I was talking about restrictions on wills under Islamic law. So under Islamic law, there are restrictions on bequest. So if you are making a bequest, then you cannot bequest on in favor of your Quranic heirs. So what this means is you might have a will, according to you, the 1/3 will be distributed in the manner which you have freedom to do. So in that, the one who is to inherit you, your heir, the Quranic heir, is not allowed to take part in the distribution of the 2/3. And bequest shall not, on the 1/3, sorry. So the bequest shall not exceed 1/3 of the entire estate after paying out all the testator's death. With this, I'd like to come to an end, to the end of this presentation, and I'm hoping that we will answer your questions. And I hope that you have all been able to gain something out of this. Thank you.
Thank you so much, Umani. I must confess that is an insightful presentation from you, and we really appreciate you. And I'm very sure the audience will also agree with us that it's an insightful one, and they must have tapped into your wealth of knowledge. So we have now come to the question and answer session. We'll take as many questions as our time permits. Already we have some questions online. So I will go ahead and read out those questions. I wish to state here that for the attendees that intend to ask other questions, kindly drop your questions in the comment section. Please, we will attend to as many questions as our time permits. Thank you so much. Umani, someone has asked this question. Ademola Adepodun has asked, that's good afternoon, Mahani. Please, if the deceased prepared his will before his death and some of his assets were to be inherited by his adopted son, I would like to know if Islam is against this act. Thank you.
Okay, so Islam does not allow you to, does not allow your adopted children to inherit. So that's why it is quite important for us to be able to plan our estate, so that in that a Muslim has the testamentary freedom to be able to do what he wants with his 1/3 of his estate. So under that 1/3, of course, your adopted children can inherit. And of course, during your lifetime, you can gift them whatever you want to gift, apart from the 1/3. So that's the only way a person can do it.
Okay, thank you so much.
Yeah.
Then Usman Liyasu asks a question. Salam, can one make wasiya for an unborn child?
Yes, yes, they can, because it's a fetus. That's why I had already mentioned as well that a fetus, it can inherit. So you can make a wasiya in respect of an unborn child. Yes, you can.
Okay.
Provided that there's already a fetus. Except, of course, you can make arrangements to say if someone gives birth to a certain person, to a certain child, whether male or female, then you can just leave that. But of course, Islam again is against uncertainties. So these are uncertain. A fetus is allowed. A fetus that was not conceived is basically almost not allowed. When I said almost, because I am not very sure of what the Sharia rulings will be regarding that.
Okay. Thank you so much, Omani. Another question is it also accepted to make wasiya that after my demise, a certain portion should be used to build a mosque or an Islamic school?
If it's within the 1/3, yes, is allowed. Except, of course, you start to build that and you have removed that money and say, okay, this is a waqf. That's why I said there are other Islamic estate planning tools you can use. One of them is waqf. Waqf is an endowment fund, and you can start that during your lifetime, and it will be sustainable forever. That's why it's called waqf. Waqf in Islam means to stop. So you have stopped any rights or interest in that certain property, and you will want it to be used for a charitable purpose.
Okay. Then we have another question from Ademola Adepodun. Good afternoon. Please, if the deceased prepared his will before his death, and some of his assets were to be inherited by his, I think we have answered that.
Yes, we have.
By the adopted son. So I will go to another question. We said, if a man dies without writing his will, what is the Islamic ruling on it?
Okay, so if you don't have to, like, it's not compulsory for every Muslim, even though it is recommended by the Prophet Sallallahu Alaihi Wasallam. I had mentioned in a hadith that the Prophet had mentioned, if you have anything that is yours, then you should at least within 2 days of 2 nights of owning that be willed the way you want. As in, you should leave a will saying, this is how I want this to be done. This is how I want this to be done. So if one does not leave a will, of course, then the Sharia principles in the Quran and then the Hadith will now be followed strictly without giving recourse to whether you have adopted children or you have probably a relation whom you are interested in giving out something to, or a parent who is not a Muslim. All of this will not be considered because you have not said anything. So the Quran and Hadith and the Quranic way of distribution of estates will be followed strictly.
Okay. So one of the attendees asked this question that can beneficiaries that have benefited under the 1/3 still benefit under the 2/3, the remaining 2/3?
No, no. If you are a Quranic heir, then you are not allowed to benefit from the 1/3. No, you are not allowed strictly.
Thank you, Mahani. Aisha Issa has asked this question, that what if the children of the deceased are still young? How long can the sharing be delayed?
So that's why again the importance of the Islamic estate planning comes in. If you have children that are very young, then you have to leave guardians and executors of their assets. So they will be in charge of these assets until they reach a certain age. So you must have guardians to look after that. That's why, and if you don't have guides, that's why I mentioned in my last bit that it is very important for you to have an Islamic will to be able to, so that your dependents, if they're young, will not suffer. And if they're in school, no one will stop their schooling. If you had started something, it will finish and they will be able to live according to the way you want. But if you don't leave a will, then there's nothing anybody can do about it.
Thank you. Babatunde Ibrahim Adekola says, thanks a lot for this presentation. Please, my question is this. What are the procedures to claim a deceased financial wealth from a bank in a situation where he left no will to be read?
Okay, so you have to get a letter of administration to be the executor of this. You have to have affidavits. It's a whole court process. You have to go on to the probate to sign off, and then affidavits from the rest of the family to show that, okay, you have been appointed as an executor who is going to act on behalf of the family. And then, of course, these letters will be taken to the banks and other agencies which you have assets with.
Okay. Dolapo Aguro has asked this question, that for how long can the deceased delay the sharing of his will?
So it is very important in Islam that immediately after the demise of a person, after his debts have been paid off, funeral expenses have been taken care of, then the next thing will be going to look at his will. If he has made any instructions according to his will, then it will be taken care of. The next thing will be to distribute his estate according to the Quran as soon as possible. It is said that usually if the deceased estate is not shared, then he won't have peace in his grave. So it is very important for the estate to be distributed immediately and as soon as possible after the demise of a person.
Okay. Isa has asked that, does a child out of wedlock entitled to inheritance even though the deceased acknowledged him or her as his child?
So there are divergent of opinions on that. Some will agree that if the deceased had mentioned and agreed that this is my child, even though out of wedlock, he's entitled to. But you know, you can't even eat your cake and have it when it comes to Islam. The rule says that a person born out of wedlock is not entitled to inherit you. He is termed as an illegitimate child. So that's why you again have the estate planning tool to be able to give that child whatever you want. You know, that's another Sharia argument, which I will not want to get into. I'm not in that realm to be able to discuss those issues that are legally is the Islamic legal issues which have different of opinions. So if that person asking the question would like to talk to us after this webinar, then we can tell him about the different of opinions and how it is done. But as far as this webinar is concerned, then that person is not entitled to inheritance, except using the Islamic estate planning tool. Thank you.
So Olugbenga Otukoya asks, why should I have a will if the Quran specifies how a Muslim person's estate should be distributed? Why should I have a will?
So for you to have a will as a human is for you to have your way, you know. Islam had specified, of course, this is how it should be, but then it gave you an exception that, oh, you might have, for example, a relation that is not a Muslim. Islam had said you cannot be able to, and during your lifetime, probably you're the one looking after that person, could be your parent. And then you can have like the others, the last person asking questions about persons born out of wedlock. You can have all of that. So Islam, even though it's specified, that's why I said in my presentation that it is not compulsory, but it is required that if you do that, then it will help you sort out a lot of your issues. Illegitimate children, non-Muslim parents, or relations, or people or relations you've been looking after. The Prophet ﷺ had spoken about how important it is for you to be able to take care of your relations, your kinship. So if you don't want to do all of that, then it's fine. You don't have to have a will, because Islam had specified exactly how it should be shared. But if you have all of these issues coming up and you want to eat your cake and have it, I must say, then of course the Islamic estate planning tool is there for you to take care of your needs. Thank you.
Thank you so much, Shumahani. Afisat Ajia says, good presentation. Is it allowed for a Christian to convert to inherit a father and mother's property in a pretext of conversion back to Islam?
I'm not sure I can answer that question again, because that's also a legal issue in Islam, which is dealt with separately, under whether a person can be a Muslim and then tomorrow you come back and say, no, I want to be a Christian, and then come back again. No, I'm not in a position to answer that.
So Abdul Aziz Momo says, can I as a Muslim distribute all my assets while alive?
Yes, you can. You can, even though Islam again frowns against it, because Islam promotes that you should be able to leave your inheritors comfortable if you can. So you, of course, it's your wealth. You can be able to do as you like. But remember, the Prophet ﷺ spoke to his companion who was very wealthy, and that is where it was said that you can leave 1/3. The companion had said he wants to give everything out, and the Prophet said no, frowned against it until he said, okay, can I give 1/3? So, but during your lifetime, if you decide to give everything, nobody stops you, but this is what is required from you as a Muslim.
Okay, so we'll take one more question because we have a lot of questions. But I want to state that for the other questions, we will attend to them after this presentation because we cannot take all the questions that have dropped in the comment section. So the last question that we're going to take for today is from Abubakar Bamtam. Abubakar Bantam says, if the deceased did not allow a will, that is Wasiyyat, and he has dependents who are not his heirs, is it allowed for his family to separate the 1/3 on his behalf?
Unfortunately, no. He has to say it, except if the family is benevolent enough to say, okay, from my shares, I will want to give this out to these people if they agree within them. But no, they cannot say, oh, they are taken out of his property. They're taken out of their property because he did not leave a will, and nobody has a right to touch it except those who are allowed to inherit the deceased. So they can't, but they can give out. There are instances where in Islam, it is said that the male and the female will take, the male will take 2 portions of what the female will take. So there are instances when the brother will come, will say, okay, I know I'm supposed to have this, but I want you to share with my sister exactly. I want to give what belongs to me to my sister. You know, that's an arrangement you can have. So the family can have an arrangement to do that, but no, it did not say, it did not take it out of the deceased estate.
Many thanks to you, Marani. Like we said earlier, and so many of the attendees have mentioned too, this has really been an insightful presentation from you. We appreciate you very much. We have now come to the end of the question and answer session. I wish to say that this session has been recorded and the recording will be made available to the attendees. And now I wish to thank everybody for taking the time out of your busy schedule to join this webinar. We have now come to the end of the session. Thank you so much.
Thank you everyone for finding time to join us on this webinar. The objective of the webinar is to encourage all of us to write our wills as an injunction from Prophet Muhammad, peace be unto him. So we have a partnership agreement with the matrimonial law firm, and jointly we will guide you to produce a will that is Sharia compliant. So we enjoin you to please visit our website, www.fcmbtrustee.com, and then we have a portal that will allow you to fill your information, and then we pick it up at back end to be able to produce a valid will for you that meets all the Sharia requirements. So thank you very much for joining us, and we look forward to seeing you next time when we have another seminar. Thank you very much.
FCMB, my bank and I.